And it appears to me that the most experienced people in our country at getting reliable information from people who are wanting to harm other people are in fact law enforcement. That's what they do. They understand interrogation techniques much better. And that's what their profession embraces, is interrogation techniques. And I can assure you that there are many instances of tough interrogation techniques within the framework of criminal interrogations within the constitutional framework of our country, but nonetheless, we have to get really solid, good information in order to keep people from dying, in order to keep people from being hurt on a constant, ongoing basis. I'm trying to figure out why there should be two sets of laws associated with that. If the goal is to get good information, why there would be two different sets of rules?
Well, that's a very interesting proposition with a lot of pieces, and let me try to address that. First, let me tell you that I have only the highest regard for the law enforcement community. I agree with you that they're skilled, professional, well-intentioned people who do great work in a particular environment. And oh, by the way, there were lots of law enforcement people at Guantanamo who were equally frustrated, including the FBI. So I don't mean for a minute in trying to describe the environment that the country faced at the time and still faces, frankly, as favoring one over another. I'm just describing the existence of a set of conflicting philosophical approaches that are fueled by very different purposes. The law enforcement community, to be sure, as you say, is there to protect us. It's there to enforce the laws and to protect us and ultimately to develop a record to prosecute and punish wrongdoers. Because of our constitutional system and our fantastic system of criminal justice in our country, we have a very generous set of procedural underpinnings that the law enforcement community has to be mindful of in the way it interrogates people.
I'm not talking about that, sir. I'm talking about what works. I'm talking about what's effective. I'm talking about how you get good information. What has been talked about over and over and over again in the Senate, in this room, in other rooms like this throughout this Capitol, is not. It's not just a matter of legal analysis. It's also what works.
Oh, I agree.
People will tell you what you want to hear. If you're torturing them, they'll tell you what you want to hear. Well, it's not an effective way to get good information, and law enforcement knows that. And frankly, I wish I didn't have to go preside, but I know my time is up, Mr. Chairman.
But Senator, I need to respond to that because nobody has advocated torture. Period. I don't advocate torture. I don't question your appreciation that effective interrogation is what we're after. I agree with that. I'm not an interrogator. I'm not an intelligence officer. I'm not an FBI person. I'm a lawyer. And my job in this exercise that we're probably going to get into at this point is to talk about what does the law permit and what does the law prohibit. And it's important to understand those two conflicting approaches from the experts, of which I am not. In trying in appreciating how I can respond to your question, did I know that there were people who had problems with the approaches? Absolutely. And I believe and believed at the time that it sprang from those things because I saw it repeatedly and I see it now. And the effectiveness of interrogation approaches is something that we all want. But in my experience as an observer, a reluctant observer over the last 6 years as General Counsel and doing some of these kinds of things that I had no idea I was going to get into when I took the job, is that it is case by case, person by person, situation by situation, and type of information by type of information as to what is the best and what is the most appropriate approach.
Thank you, Senator McCaskill. Senator Inhofe.
Thank you, Mr. Chairman. There we go. Got it working. Mr. Haynes, how are you? I appreciate your being here today. we can all remember right after 9/11, everyone was expecting something else to happen, and I think we have documentation now that there are a lot of plans out there that we successfully were able to stop, to thwart in one way or another. The Fort Dix plot, the JFK airport plot, the liquid explosives plot, and the media had quite a few things. From the Washington Post, U.S. has thwarted the dirty bomb terrorist plot. A year after, this is one that was in the L.A. Times by Josh Meyer, signals high risk on new attacks, terrorism alerts, and all that. Now, I would assume that a number of things led to and prompted the use of new techniques, and I assume that that's part of what led to the new techniques. Would you kind of tell us how does DOD change techniques and where do the new techniques come from?
I'll try to answer that, Senator, but let me respond to your opening. You're absolutely right that the context is very important. You've listed a number of incidents that I'd forgotten about, frankly, but at the time that this particular proposal that we're talking about today came up, the fall of 2002, the Defense Department had discovered months after he had arrived that a person named Mohammed al-Qahtani was likely the 20th hijacker that would have been the pilot on the plane that went down in Pennsylvania. Now, in the fall of 2002, we had just passed the anniversary of 9/11, and our intelligence people tell us that anniversary dates are important to al-Qaeda. The Bali bombings, which killed hundreds of innocent people, happened on October 12th, 2002. The D.C. snipers, which terrorized this city, had just been captured, and people weren't certain where they were from, whether they were associated with the external threat or whether they were what they turned out to be. The anthrax cases of a year earlier had still not been solved. Zawahiri, who was bin Laden's number 2, issued a video threat on October 8th, 2002, saying, quote, "God willing, we will continue targeting the keys to the American economy." Early in the summer of 2002, there were deadly attacks in Pakistan and Tunisia. There was a capture earlier that year of an American citizen who was suspected of being involved in a dirty bomb plot, and plenty of other still classified threat information. Yeah. One of the things that the intelligence community was concerned about was that al-Qahtani, who was the person who came into Orlando Airport in August of 2001, a month before 9/11, to be met by Mohammed Atta, the pilot, the ringleader of the 9/11 attacks, and had been turned away, whether he had a companion on that plane, because there were other hijackers had come into the country in pairs, and there were people roaming in the country, and whether al-Qahtani had information about other plots. So there was a high degree of urgency to deal with this. Now, your question, how do they come up with other interrogation techniques? Again, I would refer, in this case, to the previous panel that talked about that, and to the bait stamp documents that I told you. But the bottom line understanding that I have, Senator, is that the intelligence community didn't know how to deal with this, nor did the law enforcement community know how to deal with this. For al-Qahtani himself, nobody had been able to get him to talk. He claimed to be a falcon.
Yeah, I think that's very significant. We're dealing with something here that no one had dealt with before. This was new to us. Now, on the resistance portion of the SEER program, do other countries train their people? What about Israel, Great Britain, and some of the others? Do they train them, have a similar type of program?
Senator, I suspect that they do, because they're sophisticated. They have sophisticated militaries, but I am not an expert in that.
Are you familiar with the Manchester document that was found in Manchester, England?
I am. I've seen it. It's widely reported and available, and it talks about, among other things, training for al-Qaeda members who may be captured, how to resist interrogation, and what things they should claim, such as torture. Whenever they're questioned, they should claim that they're being tortured.